ethical guidelines for expert medical witnesses, and liability of expert witnesses. The physician who testifies as an expert medical witness should be guided by the following ethical considerations. First, assist justice. The expert witness has an ethical obligation to assist in the administration of justice. Second, no contingency fee. The expert witness fee shall not be contingent on the outcome of a case. Paying a contingent fee to an expert witness is not permitted in most jurisdictions. The common law rule in most jurisdictions is that it is improper to pay an expert witness a contingency fee. Third, reasonable compensation. Compensation of the expert medical witness should be reasonable and commensurate with the time and effort in reviewing the medical records and literature, writing reports, and appearing for deposition and testimony at trial, depositions, or arbitration hearings. Number 4, no advocacy. The expert witness must not be an advocate or partisan for either party in litigation. 5, recent experience. The expert witness should have recent and substantive experience in the area in which testimony is being given. 6, adequate preparation. The expert witness should be adequately prepared for rendering the testimony. 7, no bias. Opinions rendered should be unbiased. Number 8, the basis for opinion. The expert witness opinions should, where possible, be based on medical literature. Opinions which are based on personal experience should be so stated. Number 9, honesty and truthfulness. The expert witness should testify honestly and truthfully without excluding any relevant information. Number 10, no conflict of interest. There should be no conflict of interest, either actual or potential, with the client or any of the attorneys. Number 11, maintain privacy of records. The expert witness shall protect the privacy of records and communications. 12, ex parte contact, that is, informal discovery of expert opinion. If the matter is pending in federal court or in a jurisdiction that has adopted an expert discovery rule patterned after the Federal Rule 26, a lawyer is not specifically prohibited in a civil matter from making ex parte contact with the opposing party's expert witness, but such contacts would probably constitute an ethical violation. If the matter is not pending in such a jurisdiction, there would be no violation. Now let us turn to malpractice of expert witnesses, and first discuss the doctrine of witness immunity. In 1983, the Supreme Court ruled in Briscoe versus LaHue that witnesses cannot be sued for the content of their testimony. The doctrine of witness immunity has prevented the plaintiff from suing the witnesses for an adverse judgment. There are two types of witness immunity: immunity against criminal prosecution based on the testimony, and second, immunity against civil liability for harm caused by the testimony. No legal action is allowed against either an expert or a fact witness for words spoken in the course of giving evidence, even if the evidence given is false, malicious, negligent, or defamatory. The immunity rule was initially confined to evidence given orally in court. Presently, the immunity extends to all civil proceedings brought against the defendant, which are based on any statement which the witness makes for the purpose of giving evidence to the court, including medical reports, affidavits, and depositions. Well, what is the expert witness's liability? The expert witness is not absolutely immune from liability. Expert testimony by a physician constitutes the practice of medicine, and it is presumably covered by the medical liability insurance. Both the plaintiff and defense expert medical witnesses are held accountable for the veracity of their testimony. An expert witness that states untruths while testifying under oath may be held in contempt of court and charged with perjury. Additionally, state medical licensing boards have the authority to discipline physician experts who provide false or misleading testimony. State medical societies and specialty societies also have the authority to discipline their members who provide false or misleading testimony. And as noted in the several cases, expert witnesses may be held accountable to the parties in litigation for false, misleading, or negligent testimony. The grounds would be, first, the breach of contract, and second, negligence. The performance of an expert witness, both during pre-trial and at trial, is of concern to both the party that hires the expert to testify and the opposing party. The hiring party wants effective testimony as measured by a beneficial effect on the judge and jury, while the opposing party wants the expert discredited and the testimony stricken. Mere dissatisfaction by either party is not evidence of expert malpractice. Expert witness liability may be based on the breach of contract between the expert and the party employing the expert. Only the employing party could sue. If the liability is based on the theory of negligence, it is possible that both the hiring attorney and the opposing attorney who was injured by the negligence could sue the expert. Now here are a few golden rules. To protect themselves and prevent a malpractice lawsuit, medical experts should consider doing at minimum the following. Draft a detailed, clear, and comprehensive retainer contract as to the duties and responsibilities of the expert and the hiring attorney, signed and dated, which may subject malpractice disputes to arbitration. Include updated and signed curriculum vitae. Testify without bias, based on relevant, published, peer-reviewed, and validated scientific evidence generally accepted by the medical community that would assist the jury and judge in comprehending the medical facts. Be very wary of changing one's mind during trial, even when doing so might be consistent with or compelled by professional standards. And finally, physicians should check with their medical liability insurer if negligent expert testimony is covered. Remember that a conflict of interest may arise where the plaintiff's expert medical witness and the defendant physician are insured by the same liability insurance. Thank you.